I'm Dennis Brager. I'm a former IRS trial attorney and a California State Bar certified tax specialist. This is just one in a series of videos designed to give answers to questions that my clients frequently ask. Today we're discussing innocent spouse relief. Many married couples find it advantageous to file a joint tax return rather than filing separately. This comes as no surprise, as the federal government has built a number of tax advantages for married couples filing jointly into the tax code. However, there are also drawbacks to filing jointly with your spouse, especially if the relationship hits a rough patch or ends in divorce. This is because by filing jointly, you subject yourself to joint and several liability for everything that appears on the tax return. In other words, absent an exception or relief, both members of the couple are liable for everything that appears on the tax form, regardless of who prepared it or whose mistake it was. If your spouse or former spouse made mistakes on the jointly filed taxes or took an overly aggressive position, you could find yourself liable for additional taxes, penalties, and interest. Clients often ask me, when is applying for innocent spouse relief appropriate? The most common instance where issues of innocent spouse relief may come into play is where a couple is headed down the path of divorce or has already divorced. Often, one of the partners in the marriage was responsible for handling the taxes, and the other partner may have only had a limited role in preparing or overseeing the taxes. In many situations, the other spouse may do little more than simply sign off on the return while trusting that his or her partner prepared the taxes thoroughly and accurately. At some point, the spouse who participated only minimally in the tax preparation process may suspect that his or her spouse has understated income, overstated deductions or exemptions, or otherwise violated the tax code or even committed tax crimes. The innocent taxpayer does not want to remain liable for these outstanding tax debts and penalties because he or she did not create them or cause them. It may be appropriate for a spouse in this or in a similar position to file for innocent spouse relief. To apply for innocent spouse relief, a taxpayer must file Form 8857 with the IRS. The form must detail and explain why the taxpayer believes that he or she is entitled to such relief. While the form seems quite simple on its face, there are all sorts of technicalities which non-tax experts won't be able to readily identify. Once the Form 8875 is signed under penalty of perjury and filed, any mistakes are extremely difficult and often expensive to undo. That's why we recommend that the form be prepared by a professional with lots of experience in innocent spouse cases. After the Form 8857 has been filed with the IRS, all enforced collection action will come to a screeching halt. By filing Form 8857, you are asking the IRS to establish a separate tax liability for you that is separate and apart from that of your current or soon-to-be former spouse or ex-spouse. On the form, you must provide information regarding your role in the tax preparation process, whether you were aware of the unreported income, and if you had reason to know about the inaccurate statements on the tax form. Depending upon the type of tax relief requested, the filing taxpayer may be required to prove that it would be unfair to hold him or her liable for the taxes. Whether something is fair or unfair can be highly subjective, but the IRS has provided criteria to help in making this determination. Elements the IRS will examine include whether it would be fair to impose the tax against the spouse filing for relief, include the nature of the erroneous items or items on the tax filing, the value of the erroneous item or items relative to the remaining items on the tax return, the level of participation by the filing taxpayer in the mistake, the filing spouse's experience in business dealings, the filing spouse's educational history, the financial circumstances of each spouse, whether the filing party failed to ask reasonable questions about the return prior to signing, whether the understatement is part of a recurrent pattern or an isolated incident. All of these items will be considered as part of the inquiry as to whether it would be fair to impose the tax liability and decline to provide relief. There are other options for innocent spouse relief which may be useful for some taxpayers, but other requirements may also apply. For instance, an application for relief must generally be filed within 2 years of the first collection action taken by the IRS, but like everything else in the tax law, there are exceptions. Call us to find out more about how the innocent spouse rules apply to your situation. If you found this video helpful, please let me know by leaving a comment. And if you would like me to update you when I post a new video or send out a newsletter, please send an email to taxhelp@bragertaxlaw.com. That's taxhelp@bragertaxlaw.com, all one word. Thank you for watching my video and have a great day.